BPD unlawfully restricts protected speech, page 117. The people of Baltimore have a constitutional right to observe and verbally criticize the police. Since the day the ink dried on the Bill of Rights, the right of American citizens to criticize public officials and policies is the central meaning of the First Amendment. We found that BPD officers routinely infringe upon the First Amendment rights of the people of Baltimore City, typically in one of three ways. First, we found that BPD unlawfully stops and arrests individuals for speech they perceive to be disrespectful or insolent. Second, we found that officers retaliate against individuals for protected speech through the use of excessive force. Third, we have concerns that BPD improperly interferes with individuals who record police activity. 1. BPD unlawfully detains and arrests members of the public for protected speech. BPD detains and arrests individuals for speech perceived to be rude, critical, or disrespectful. These arrests described by the officers in their own words and incident and arrest reports violate the First Amendment. For example, an officer in downtown Baltimore in 2011 felt that it was reasonable to order a young African-American man to leave the area because he had no respect for law enforcement and was making idle threats towards a uniformed officer. As the young man walked away accompanied by a friend, the two made additional comments mocking the officers and the BPD. 15 minutes later, the officer again spotted the two men in the same area and placed both under arrest for failure to obey. The freedom of individuals verbally to oppose or challenge police action without thereby risking arrest is one of the principal characteristics by which we distinguish a free nation from a police state. By ordering the young men to leave and then arresting them for their comments, the officers violated their First Amendment right to violated their First Amendment right to peacefully and verbally criticize or oppose law enforcement officers without actively interfering with the officers' lawful performance of their duties. In another incident from 2011, BPD officers arrested a man for disorderly conduct after he refused to leave a public area following an order issued without just cause and yelled "fuck you" repeatedly at the officer. This arrest was also unlawful, as individuals may not be punished for using vulgar or offensive language unless they use fighting words, that is, words that by their very utterance inflict injury or tend to incite an immediate breach of the peace. From our review of their report, some BPD officers appear to believe that use of vulgar or profane language provides probable cause to arrest or grounds for ordering a person to leave a location. Indeed, in another case, an officer patrolling the Inner Harbor on the 4th of July complained that a man, Nicholas, bumped his shoulder while walking past. As Nicholas continued walking, the officer said, "Hey, you ran right into me," to which Nicholas replied, "Fuck you," and continued walking. Although no crime had been committed, the officer pursued Nicholas and demanded his identification. Nicholas continued to walk away from the officer, who attempted to grab his arm. Nicholas swore at the officer again and continued to pull away, at which point the officer informed him he was under arrest. According to the officer's report, after attempting to place the man under arrest, the incident ended in a physical altercation between officers Nicholas and his brother, with the brother eventually being tased. Though Nicholas made repeated attempts to walk away peacefully, the officer pursued him and escalated the encounter. According to the officer's report, he believed that Nicholas's attitude and actions indicated he was purposely looking for a confrontation with law enforcement. However, Nicholas made no obvious threats or aggressive movements towards the officer. His use of profanity did not rise to the level of fighting words and was protected by the First Amendment. The officer's pursuit, detention, and eventual arrest was an unlawful exercise of government power to exact personal vengeance for a perceived slight. BPD retaliates by using force against individuals who engage in protected speech. BPD uses unreasonable force to retaliate against individuals who engage in protected speech critical of law enforcement in violation of both the First and Fourth Amendments. We reviewed a number of troubling incidents where BPD officers appeared to use force against individuals simply because they did not like what those individuals said. In one case from 2011, officers tackled and used a taser to drive stun a young black man who was, in their view, loitering near a market during business hours in downtown Baltimore. When told to move, the young man refused and swore at the officers, who then tackled him. Nothing indicated the man was armed, violent, or presented a danger to the officers or others. Supervisor who investigated and approved the incident failed to recognize that the force appeared to be retaliatory, even though the man, when interviewed, told them he believed he was tackled because he cursed at the officers. Concerns that BPD interferes with the right to record public police activity. We also have serious concerns that BPD officers interfere with individuals who attempt to lawfully record police activity, although we do not make a finding of constitutional violations in this area because we did not find a sufficient number of incidents to warrant such a finding at this time. We nevertheless received and reviewed a number of allegations that BPD officers seize, view, and destroy video and audio recordings that constitute private property without just cause to do so. In 2012, we provided guidance to BPD on the First, 4th, and 14th Amendment considerations relating to the recording of public police activity and a statement of interest filed in Sharp versus Baltimore City Police Department, 2012. That case was brought by the ACLU of Maryland on behalf of a man whose cellular phone was seized by BPD officers during an incident at the Pimlico racetrack in 2011. The city settled the case in 2014 for $250,000. The plaintiff alleged that BPD officers seized, searched, and deleted the contents of his phone after he used it to record officers using force during an arrest of his acquaintance. When BPD returned the phone to him, all of the videos on the device were deleted, including a number of personal videos of his young son. After the man filed suit, BPD moved for a partial summary judgment, and the Department of Justice opposed that motion in our statement of interest. Shortly thereafter, on May 14, 2012, in advance of the party settlement conference, we sent a letter to both parties. In our letter, we described in more detail how these constitutional interests play out in practice, and we gave technical assistance on their application for policy and training. The parties settled, and as part of the settlement, BPD agreed to implement a new policy and training program concerning the right to audio tape, videotape, and photograph BPD officers during the public exercise of their duties. The new policy was published in 2014. Nonetheless, in the time period since Sharp, we have received numerous allegations that BPD officers continue to interfere with the individual right to record police activity in violation of the First Amendment and their own policy. One example of the allegations we received stems from an incident in 2015. According to the complainant, a young man was charged with 3 offenses after filming BPD officers arresting his friend for trespassing outside a nightclub in Baltimore City. The friend was engaged in an argument with security officers at a bar complex about refunding his admission fee. When BPD officers informed him that he was trespassing and began handcuffing him, his companion, allegedly standing approximately 20 feet away, began to film the incident using his phone. 2 other officers on the scene turned and confronted him, grabbing his phone and placing him in handcuffs. While the alleged trespasser was released with only a ticket, the man filming was arrested and charged with 3 offenses: failure to obey, trespassing, and assault for what appears to be a later discovered alleged assault against a nightclub's bouncer. During the arrest process, the man watched as an officer openly went through his phone. When BPD released the man after he spent 2 nights in jail, he discovered that the video of the incident had been deleted. Ultimately, a state court entered a judgment of acquittal for the assault and failure to obey charges, and the man was acquitted of the trespassing charge at trial. According to the man, the sole justification for his arrest was his attempt to record the officer's interaction with his friend. We also note that to the extent that the officers thought that the man recording their activities was somehow interfering in their enforcement efforts, the officers do not appear to have made any effort to instruct the man who was recording them to move to a less intrusive place where he could continue recording. Yeah, okay. BPD's handling of sexual assault investigations raises serious concerns of gender-biased policing. Our investigation also raised serious concerns about how BPD responds to and investigates reports of sexual assault. 1. Evidence of gender bias in BPD's response to sexual assault. A. Treatment of victims of sexual assault. By its very nature, sexual assault is a crime about which it can be difficult to ascertain the facts. For example, sexual assault often occurs in a private setting with no witnesses other than the people involved as the victim and suspect, and victims of sexual assault are often reluctant to report the assault, particularly to law enforcement. For that reason, victim advocates who act as confidants and guides for victims as they navigate the criminal justice system, and whose role affords them a unique perspective from which to identify patterns in their clients' experiences, play a critical role in providing information about sexual assaults to BPD. The information provided to us by victim advocates and in some cases by victims of sexual assault themselves, together with our review of BPD sexual assault case files and related documents, raise serious concerns about gender bias in BPD's treatment of victims of sexual assault. For instance, officers and detectives in BPD's sex offense unit often question victims in a manner that puts the blame on for the sexual assault on the victim's shoulders, for example, with questions suggesting the victim should feel personally responsible for the potential consequences of a criminal report on a suspect or for having engaged in behavior that invited the assault. In their interviews of women reporting sexual assault, for example, BPD detectives ask questions such as, "Why are you messing that guy's life up?" BPD officers and detectives also ask questions suggesting that they discredit the reports of victims who delayed in reporting the assault to the police. This type of question is inappropriate in a detective's interview of a potential victim of sexual assault and suggests gender bias by the detectives. We are also troubled by statements of BPD's detectives suggesting an undue skepticism of reports of sexual assault. One victim advocate told us about a detective in the BPD sex offense unit making comments at a party in the company of BPD officers and victim advocates that, in homicide, there are real victims. All our cases are bullshit. When another person suggested the detective soften the statement, the detective added, "Okay, 90%. We also reviewed email correspondence between a BPD officer and a prosecutor in which they openly expressed their contempt for and disbelief of a woman who had reported a sexual assault. The prosecutor wrote that this case is crazy. I am not excited about charging it. The victim seems like a conniving little whore, pardon my language." The BPD officer replied, "Laughing my ass off, I feel the same." BPD's treatment of transgender individuals, page 124. We received allegations of BPD's officers' mistreatment of transgender individuals and have concerns that BPD's interaction with transgender individuals reflect underlying unlawful gender bias. We heard allegations that BPD officers make disparaging and inappropriate comments to transgender individuals and that BPD officers refuse to acknowledge transgender women as women. One transgender woman, for example, described an incident after a traffic stop in December 2015 in which she was asked by the officer whether she identified as male or female and told the officer she identified as female. Despite her response, the arresting officer then said to another officer at the scene, "Well, are you going to transport him?" We also heard from the transgender community that their interactions with BPD are degrading and dehumanizing, and that as a result, transgender individuals are afraid to report crime to law enforcement. The same transgender woman described above, for example, alleged that when she arrived at intake, the female supervisor who was called to search her said, "I am not here for this shit. I am not searching that." When she then tried to ask the supervisor to show her some respect, the supervisor said, "Like I said, I don't know you. I don't know if you're a boy or a girl, and I really don't care. I am not searching you." This is not the only example we heard about BPD officers conducting inappropriate searches of transgender individuals. We heard several reports that indicate that BPD officers lack guidance on the appropriate process of conducting searches of transgender individuals, including ensuring that their searches are conducted by a person of the appropriate gender. BPD's treatment of women victims of sexual assault and of transgender individuals should not reflect gender-based stereotypes and assumptions that may compromise the effectiveness and impartiality of BPD's response to reports of sexual assault and discourage women and transgender individuals from engaging with the criminal justice system. BPD fails to adequately investigate reports of sexual assault. BPD seriously and systematically underinvestigates reports of sexual assault, and the sexual assault investigations it does conduct are marked by practices that significantly compromise the effectiveness and impartiality of its response to sexual assault. These are not new issues for BPD. BPD's handling of sexual assault was subject to widespread public scrutiny in 2010, spurred by media reports of BPD's misclassification of rape cases, failure to identify and investigate reports of sexual assault, and substantial backlog of rape kits. Victim advocates, for example, criticized the manner in which BPD treated victims of sexual assault, including interrogating rape victims, questioning women in the emergency room, threatening to hook up women reporting sexual assault to lie detectors, and not informing victims about the status of their cases. Moreover, victim advocates reported that BPD's sex offense unit was only minimally investigating reports of sexual assault. For example, they were not making efforts to identify witnesses or submitting rape kits for testing. Despite some attempts at reform by BPD and Baltimore City leaders, most of these problems either remain or have returned. BPD's response to reports of sexual assault is overall grossly inadequate. For example, BPD allows more than half of its rape cases to linger in an open status, often for years at a time, with little to no follow-up investigation, while fewer than 1 in 4 of its rape investigations are closed due to the arrest of a suspect, a rate roughly half of the national average. BPD detectives request testing of rape kits in fewer than 1 in 5 of BPD's adult sexual assault cases, leaving these rape kits to sit untested in BPD's evidence collection unit, and BPD detectives rarely if ever seek to identify or interview suspects or witnesses, even in cases where they are clearly identified by the woman reporting the assault. In addition, BPD's investigative policies and practices significantly undermine the quality, effectiveness, and fairness of BPD's response to reports of sexual assault, making it more difficult to uncover the truth when sexual assault allegations are made. Failure to develop and resolve preliminary investigations. In the majority of BPD's sexual assault cases, BPD fails to pursue investigations beyond the immediate preliminary response to a report of sexual assault. According to BPD's own data, for example, between 53 and 58% of its sex offense cases were in an open status each year between 2013 and 2015. In our own review of a sample of BPD sexual assault cases between 2010 and 2015, we found that more than half of these cases were described by BPD as being in an open status, and thus only a preliminary investigation had been done in a substantial proportion of these open cases. One sexual assault case, for example, was identified by BPD as open despite the fact that there had been no activity on the case since February 2013. In this case, there had been no request for a lab test kit, no follow-up with the suspect's lawyer to interview the suspect or test DNA, and no indication of communication with the victim over the past 3 years. Indeed, it appeared that from the file that the communication with the victim and BPD's investigation of the case had slowed and ultimately stopped after the suspect hired a defense attorney. Failure to identify and collect evidence to corroborate victims' complaints. Similarly, BPD makes little, if any, effort to corroborate victims' accounts of their assaults, either by identifying and interviewing witnesses, gathering other types of evidence, or identifying and interrogating suspects. BPD routinely fails to contact witnesses to sexual assaults in the first instance, and where their initial attempts to contact witnesses fail, BPD almost never makes a second attempt to contact those witnesses. Even when a victim describes having reported assault to others in the immediate aftermath of the crime, BPD makes no effort to identify and interview these outcry witnesses. In other words, the people who first heard the allegation of sexual assault. In one case, for example, the victim had immediately told her father and other witnesses about the assault. However, BPD made no attempt to contact any of these outcry witnesses to corroborate the victim's story. Similarly, BPD persistently fails to make any effort to contact eyewitnesses to sexual assaults. In one case, for example, the victim and the suspect had been in 2 different bars together before the assault. The victim believed that the suspect had drugged her and she had injuries all over her body. After the assault, the victim had run out of a bar and immediately reported the crime. Given these facts, it is reasonable to expect that there would have been numerous people who would have seen the victim and the suspect together or at or around the time of the assault and who would have corroborated details of the victim's account. But BPD made no attempt to contact the bartenders of the bars or to identify any other eyewitnesses. All right, I'm going to stop it here at 1940.